Let me see if I can get my video going here. Start video. Okay. Everybody should be able to see me now. And good afternoon. It is, can you believe it? It's another Zoom Landlord-Tenant radio show every Saturday at 3 p.m. Welcome all the guests. Hopefully you'll find this entertaining. I want to give a shout out to the Apartment Owners Association. They were instrumental in having that $1 million trade show at the Long Beach Convention Center. And it was, I would say, a pretty good success. We had over 2,500 people attend. I gave a nice seminar at 3 p.m. in the afternoon, and everybody, I think, had a great time. So I do want to thank all the attendees. I do want to thank the Apartment Owners Association for just putting on really such a quality show that they do. They do it once of course, at the Long Beach Convention Center. And of course, they do it also in the Los Angeles Convention Center. That will be coming up, I believe, next April. But in any event, welcome everybody. The way this works is that we offer information. We don't try to state that this is legal advice. If you need legal advice, ladies and gentlemen, what you really need to do is you really need to hire an attorney. We're a good attorney, but again, this is just for informational purposes only. If you want to have a question, what you need to do is you need to raise your hand. And by raising your hand electronically, by clicking on where it says raise hand on the bottom, you will be able to have your question answered. We'll pick on you. You'll be able to ask your question. I'll be happy to answer it. I did want to talk about, I see Alejandro's raising her hand. I did want to talk about today, before we get started, something that's coming up in the not too far from now, and that is dealing with the Los Angeles Rent Stabilization Ordinance. So those people who have properties in Los Angeles that's under the Rent Stabilization Ordinance, ladies and gentlemen, it's been 4 years before the morons who run our city council for Los Angeles and our wonderful moronic mayor. Right now it's Mayor Bass, but we have gone 4 years without a rent increase. It is incredible with the consumer price index rising. We see for prices of gas, what we see for prices in our markets, and what it costs now to have a serviceman come to your building. Remember what it used to cost to have a plumber come and maybe unclog a drain? Do you know how much it costs now? It's almost 3 times the price. The city of Los Angeles instituted their own, quote, trash pickup during this 4-year period, where we have to use only one company. We can't do it like a capitalist society where we try to pick the least expensive company. We have to pick only waste management only. And guess what? Our trash fees tripled. And during all this time, when we had all these raises in our expenses, the city council for the last 4 years said that we could get nothing, ladies and gentlemen, no rent increases. Well, the time is almost here. On February 1st, 2024, whoop-de-doo, our city council is now allowing us to do a rent increase of 7%. 7%, ladies and gentlemen. You have to serve your notice, which is why I'm talking about it now, 30 days before February 1st. And if you mail it, and most people do mail the rent increase notices, then you have to allow another 5 days for mailing. So if you do the math, you'd have to mail it on Christmas Day, December 25th. So I don't think that's a smart idea. So if you are going to raise the rent, if you are, and please do, you've waited 4 years for God's sakes, then at this point in time, what you need to do is to send it, I would suggest December 15th. Send it December 15th for that 7% rent increase and have it effective as of February 1st, 2024. So by doing that, you will then have the proper rent increase as soon as that magical day hits. Now, we've had other people who have asked, well, you know, they moved in 2 extra people, and during this pandemic, I knew I couldn't evict them, but I don't really want to evict them. I just want to get the additional rent. And I know that under the rent stabilization ordinance, I'm entitled to 10% for each additional adult who moved into the unit. If they have a child that was born, the first child is free. So, but if they moved in 2 extra people, and that's okay with you, but you want to get more money, the city said that you could get 10% for each additional person who moved in violation of the rental agreement. Well, in this situation for the last 4 years, you couldn't do a rent increase. So the issue I've been asked is, can I do it as of February 1st and raise that rent? And the answer is, well, it really hasn't been discussed by the city council, but I'm advising all my clients do it. So not only are you going to serve a 7% rent increase on December 15th to take effect on February 1st, okay? I also recommend that you also do an additional notice for an additional 10%, which will take effect as of April 1st, because you're going to need to serve a 90-day notice because you're already raising it 7 plus now an additional 10, that's 17. So you're going to do it as of April 1st, serve this. You can serve 2 notices at the same time, one for 7%, and then calculate what it will be in 90 days, which is a total of 17%. When you take that 10%, don't do it on the rent plus 7. Just do it on the 10% on the base rent, then add that 10%, add the 7%, and that's what will become effective as of April 1st. So that's the little tidbit from Dennis Block. By the way, if anybody ever needs us, we do have a website. It's evict123.com. And also, if anybody needs to call our office number is, it's pretty simple. You don't even got to write it down. It's 1-800-77-EVICT. And whether you're a client or not, we are happy to answer your questions at no charge. Just call up and you'll get into our queue and we will answer your questions. So that's how I'm starting off our show today. I want to welcome everybody. I'm going to start asking questions of people right now. And the first one I'm going to ask is our good friend Carolyn Falk. I'm going to unmute you. And if you're there, Carolyn, if you could ask to unmute. Oops, where'd you go? Julia, somebody's here. Where did Carolyn go? Carolyn, can you hear me?
Yeah, I unmuted.
No, Carolyn, I can hear you.
Yeah, okay.
So no, this is Fremont. Well, maybe, yeah, let me block you for a second here. Okay, well, Carolyn, if you're muted, then please just speak. How can I help you?
Okay, you can help. Oh yeah. So what you just said was the 10%, but that's only if they violated the lease of adding new people.
Yes, if they add new people under the rent stabilization ordinance, you have 2 choices. You can call me on Monday. I'll serve them with a notice to get rid of the strangers, and then we can evict everyone from the unit. But if you would rather say, you know what, let them stay, I just want my extra 10%, you're entitled to an additional 10% for each additional person that joined the tenancy.
After that date, or because say they added people like 6 months ago?
Well, 6 months right now, do it right now, because you weren't allowed to raise the rent for this whole time period.
Okay.
So right now we can do it.
All right, 2 questions only. So what is the statute of limitations to evict a tenant? First question, what's the statute?
Statute, let's go to one at a time, because that's the way I operate. Okay, I don't know what you mean by statute of limitations.
mean, how, like, if they didn't pay rent, and then like, how long can you wait before they evict them?
Okay, well, first of all, right now, anybody who owes rent from basically from February of 2023 to now, you can certainly do an eviction. Technically, the statute of limitations, if you want to use that terminology, would be that you can only ask for rent that's owed within 1 year. So right now, for example, we're in the month of October. So technically, you could go back to November of 2022 through October 2023. That would be 1 year. However, because of all this pandemic crap that they placed on us for no particular reason, here's the deal. Right now, if you want to evict a tenant, we're recommending who hasn't paid current rent, you can go from April 2023 through now, October, and that's a 7-month period. If people owe you rent within that 7 months, you can do an eviction right this moment. But if you have old rent that was owed, and the old rent would be any rent from, let me see if I can find this real quick. Let's see, I might not be able to do this, but let me check and see if I can. See if I can share the screen here, because this would be a little easier. And, oh yes, I can do this. This is pretty good. Okay, so now if we're looking, I think everybody can see the due dates. If you have a tenant that owes you rent from March 2020 through September 30th, 2021, you can either sue them in small claims court for it right now, or you can hire me and I'll start an eviction for any rent owed during that period of time, March 2020 through September 30th, 2021. If a tenant owes you rent from October 2021 through January 31st, 2023, then you have to wait again until February 1st, 2024. So make a mental notes of those dates, but that's when you can increase your rent for that period of time. And excuse me, that's when you can go after that person.
Okay, the second question is related to this first though. So that say the tenants didn't pay for like August 2021 through January 2020. Oh, sorry, August 2021 to.
Okay, the two periods were March 2020 through September 30th, 2021. If that's due right now, but if they didn't pay rent from October 2021 through January 2023, then that means that you can't start an eviction or sue them in small claims court, even if they vacated the unit, until February 1st, 2024.
Okay, so if they did not pay and then they started paying rent again, like say 2022, you can still sue.
Yeah, we can start those cases right now. And that's what we have been doing.
Last little thing. So say they feel like they owe a lot and then they disappear and we're trying to sue them in small claims court. How do you collect?
Okay, well, you can certainly sue them in small claims court, but as you're suggesting, the first thing you do after you file the lawsuit in small claims court, you have to serve them. Well, where the hell did they go? They didn't tell you where they were going. If you know where they work, well, then you can always sue them over there. But if you don't know where they work, then what do? So the issue is probably nothing, because you see, that's what the politicians were hoping for. They were hoping that when they told you, well, we're not telling you that this rent is free, we're just deferring the rent. Well, really, we're not going to get our rent. You know it, I know it, and God knows it. If you are a client and if you've ever used a case with us, if you call us after the tenant's been out by 6 months, we're debt collectors, so I probably will be able to locate them. So if you are one of our clients, I'll do that at no charge, or if you're a concierge member, I will do that at no charge for you. Okay, we're going to move on, but thank you very much for your question. Thank you. Okay, let's go back up to the top. I'm going to go over to my good friend Carl Fremont. And I'm going to ask him to unmute himself.
It's Kurt. Thank you, Dennis. Thank you for taking my
close.
question. I appreciate your show and I appreciate you being here. When you Google RSO rent increase 2024, this is what it says. Under the RSO, the allowable rent increase from February 1st, 2024 through June 30th, 2024 will be 7%. unless amended by council. So I have two questions. The first, why, do you know why is it from, I know it starts February 1st, but why did they say through June 30th, 2024? Does that mean on July 1st, I couldn't raise the rent 7%? Do you know why it's only a 5-month window? I just wondering if you have any information on that.
This is my understanding, and I think I'm correct. They're going to give you a new rate on July 1st. So July 1st, they'll say, if you're going to raise the rent now, it's going to be. So they're giving you a short time just to get 7%. And then probably on July 1st, 2024, they'll drop it down to 3%. This is the insidious nature of the city council. So they're giving you just a 3-month window to get your 7%. And God
Right.
forbid, because you know it's not going to be 7% come July, right, of 2024. So that's, I
Right.
think, the reason why they did it.
But we can still only raise the rent once a year, right? I mean, we can't hit it with another rent increase.
No,
July
that's right. It
1st.
would only be once a year, but if you didn't do it, then they're going to punish you by
Yes.
probably dropping it. And that's the
Right.
reason why our good friends did that.
And then thank you for that. And then my last question is where it says 7% unless amended by city council. Have you, I know you don't read the tea leaves and neither do I, but it's like, I guess, what I'm asking myself out loud, is there a chance that the city council, knowing who they are they going to say, oh, this is too much, let's amend this to a lower amount before February 1st?
I think they were covering their ass by
Uh-huh.
putting in that statement so that if they got a groundswell of support by these tenants who just want to see how much they could steal, they could cover themselves. I don't think it's going to change.
Okay. Thank you so much for your time. I appreciate it.
My pleasure. Okay, so let's move on. I am going to take, oh, this sounds very sexy here. I'm going to take Lola. Lola, I'm asking you to unmute.
Hi,
Okay.
Dennis.
Hello. Oh, look at that. You look beautiful today.
Oh, ice cream. I have a
Oh, wait a
question.
second. I got to ask, is this like the Zoom background?
No, this is just a picture of a dinner.
That's beautiful. And I see it's kind of like a custard and you have that gold leaf, but I bet you that gold leaf is edible. Am I right?
Yes, it's a miso ice cream with gold leaf.
Perfect. And where did you have this dinner?
Vegas.
Ah, well, of course, they're always so glitzy in Vegas. Okay, well, I want you to know you look beautiful and I'm ready to eat. But
Thank you very much.
how can I help you, Lola?
Property is located in San Bernardino County,
Okay,
and tenant's dog went out a open gate and bit someone. We don't know the details. We don't know if that someone is gonna cause any trouble or going through lawsuit. Do I have the right to serve 3-day notice for the tenant to remove the dog?
well, first of all, does the rental agreement prohibit dogs?
The
Most
rental
agreements
agreement
do,
does.
darling. Did you give them permission to have a dog?
I'm aware of the dogs, but it's not on the rental agreement. They've been there for 8 years.
Okay, so then what you could do is I would give them a change of terms of tenancy that in 30 days you must remove your dog. And then if they don't, then we could serve them with a 3-day notice to get rid of the dog. And if they don't get rid of the dog, then we have the right to evict the dog and the people.
Okay. I've already served the 60-day notice to terminate the lease.
Well, let's talk about that. Is this a single family residence?
Yes,
Is there only one house on the lot?
yes.
Okay. And when did these tenants move in?
They moved in 2014.
Perfect. Okay, assuming you used the proper notice that either prior to the notice or on the notice, it said that this property is exempt from statewide rent control. I presume it is?
Yes.
Okay, perfect. So that's a better way to do it. If they're still there at the end of the 60 days, then we have the right to bring forth an eviction. When did you serve the 60-day notice?
I served it about a week ago. I personally serve
Okay,
it
so
and I
and-
mail it.
And rent's payable on the 1st?
Yes.
Okay, so here's the deal, young lady. Take rent for the month of November. Don't take any further rent ever, because otherwise you'd be vacating your notice. Okay, so take next month's rent, but don't take any rent thereafter. And if they're still there at the end of the 60 days, you know what? I know this really sharp, good-looking attorney that can help you.
In just to clear, their move out date on the notice is December 31st. So
Okay,
I
so then you
should,
didn't serve a 60-day notice. You served a notice to quit saying, hey, get out by the end of December, which is perfect. So in that situation, you can ask you can take November, you can take December. And then after you wake up from eating this in Las Vegas on December 31st, New Year's Eve, go over there. If they're still there on New Year's Day, then we have the right to evict. I'm going to
Okay.
move on, but thank you for your question. We do got a lot of people here, so I'm trying to get through as many as we can. And the next one I see is Ray. It looks like Ray Joseph. I'm going to ask you to unmute yourself, young sir. Are you there?
Yes, I am. I'm here.
Oh my God, look at you.
What?
Is that like a beach behind you?
Yeah. Live in
Where-
Manhattan
where-
Beach.
You're in Manhattan Beach? Oh my
Yeah.
God, what a lucky guy you are. You get to see the ocean every day. Or I slave in my office. This is not fair.
Yeah, I way overpaid like $1 million for this place.
You know what? I don't think so. Anytime you can smell the ocean, that's $1 million right there. Anyway, nice seeing you and nice talking to you. How can I help you?
Yeah, I've got a client and someone just inquired about, he's got a rental there and they're Section 8. And what are the hazards of, one, having a Section 8 tenant, and two, if you refuse the Section 8 tenant?
Okay, under California law, they do not allow us to just reject an applicant because it's a Section 8. Up until that law, which passed a couple of years ago, I always advised all my clients never take a Section 8. However, I do have many clients that do, and it's a great business model, and they make money and they're happy. I find that many of my clients don't like the regulations, the inspections, the additional wear and tear that seems to occur when it's a Section 8 tenant versus someone else. I don't know why. I'm not talking about psychology or sociology, but it seems to be that the much more wear and tear for those units. But in any event, you don't have the right to just summarily reject. Now, you can reject a tenant, a Section 8 tenant, on the basis of credit. So while you just can't say, I'm not going to take your application, you can take the application, run the credit check, and quite frankly, you know what? It's going to show that probably they got bad credit, and you're not going to have to take them anyway because you're going to reject them, not because they're Section 8. You're going to reject them on the basis that they are not credit worthy. Now,
All right, what is not credit worthy?
well, credit worthy is they got a bad credit score. You know, if you're going through any of the associations, if they've got, you know, in the low 600s, you have to set a criteria for what you want for your tenants.
Gotcha.
If it's 650 or higher. Now, there's one other thing you can do, and that is, and I'm recommending this now, no matter what type of residential property you're leasing, only do it on a month-to-month tenancy. And there's
That's what I'm telling all my clients.
for that. I know everybody does a 1-year lease. I recommended a 1-year lease based on the law in the moronic state of California, which never saw an income property owner that they liked. It is not to your advantage anymore to rent it. Now, Section 8 will not take your agreement unless you agree to do it on a 1-year lease. So your position is, please, I want this tenant so bad. I want to be on Section 8. I'm just not giving a 1-year lease. Section 8 will reject you, and that's a way of defeating the
Oh, good idea.
Did you have a follow-up question?
So then I should make sure that the listing does not say 1-year lease, it says month to month.
You got it, sir.
Okay. No, greatly appreciate it.
All right. You take
Anything
care.
else I should be worried about in this situation?
I don't think so. I mean, it is what it is.
Okay, all right, great, thank you.
All right. If you could mute yourself, I'd appreciate it.
Thank you.
All right, now let's move on. I see, it looks like Joe's pretty good here. Joe Salavami. I know I messed up your name. I'm sorry.
It's Salvamini.
I was close. Come on.
Yes, you were. Yes, you were. Dennis, I understand that RSO properties, and I have one, a fourplex, that I'm allowed to raise the rent 7% as of February 1st, 24. I need to give a 30-day notice, and I need to send that notice out no later than December 15th to be on the safe side.
Correct.
Can I send that out now?
Technically, you could. Nothing would prevent you from doing that.
Okay.
I'm just saying that I think December 15th is like a drop dead date.
Okay, and then also I have a single family residence, there's only one house on the property in the city of LA. Am I still limited to a 7% raise in rents on that property?
Glad you asked that question. For a single family residence with only one house on the lot, you can raise the rent to whatever you like, whenever you like. As high as you like, as many times. You can't do it to try to like say, hey, I'm really trying to get you out, but you can certainly raise it to market level. Nothing prevents you from doing that. So I definitely recommend that you raise your rents to the highest level that the market will bear. I said it on a previous Zoom meeting that if you want to see what your house is worth, there's a free service, which is great. It's called Rent-O-Meter. That's RENT, the letter O, meter, METER.com. It'll give you 5 free chances to look. You put in your address, you put in how many bedrooms, you put in whether it's a house or whether it's an apartment or a condo, and they'll come up with 20, 30 units that rented within the last 6 months within a mile or a mile and a half radius of your property. So you can really see what your property is worth, what other wonderful landlords are getting for their units. So on that basis, put that in and make sure. We don't know where this is going. Honestly, we don't know where it's going with our politicians. I think their issue and what they're attempting to do is to basically put every mom and pop owner out of business so that only multi-units, 100 units, 1,000-unit corporations will be doing this, and they'll take our property. I know it sounds like a conspiracy, but that's where I see this going. They'll take our property and they'll use it for homeless or their own causes, and they'll know that we'll be selling it cheap based on what they're doing. So get your rents to market level, because you just don't know what the politicians are going to do.
Now, do I need to give for the single family residence home in the city of LA? Do I need to give a 30-day notice to raise the rent, or is it different? Because I
Good
hear
question.
you talk about a
If
90-day notice.
if you're going to raise the rent 10% or less, it's a 30-day notice. If you're going to raise the rent more than 10%, it's a 90-day notice. And don't forget, if you mail it, you got to add an additional 5 days for mailing. Okay.
Okay. Thank you very much.
Hey, thank you, sir. Okay, moving down on my list here. Let's see. I see. I don't think we talked to Leslie Hope, so let's talk to her. Are you there, Leslie? Unmute, please. No, Leslie?
Yeah, I'm here.
Oh my God, look at you, girl. That's a nice background behind you.
Thank you. My issue is I have a non-RSO property in Los Angeles. It is Section 8, so I have to serve the notice 2 months in advance.
Well, let me slow you down.
Okay.
Number one, this is an apartment house?
It's a duplex on a property that has 4 units.
Okay, but this particular unit was built after 1979, correct?
No.
It was built
in
prior to 1979?
23, something like that.
Oh, okay, so when you say it's non-rent control, you're under the rent stabilization ordinance for the city of Los Angeles because it's a duplex.
No.
Okay, tell me why.
Okay, years ago, I've had these apartments since I was very young, like about
Did you get a
40,
luxury
35,
exemption?
35, 40, yes, that's what I
Okay,
have.
so this is a very little known rule in the land of LA rent control, that back when this started back in 1979, if you had and I even remember this rule, and I don't know why, but if you applied and you had a luxury unit, you would get a permanent exemption. The luxury unit, there was two ways to get an exemption. One was if you had a 2-bedroom, and I remember it was $588. That was considered a luxury unit. You might have done it that way, or the other way to get an exemption was you did a renovation of the unit and you spent $10,000 or more, then you got it permanently. Okay, so you're not under LA rent control, but my love, you are under rent control. Do you know?
I know, California, that's my question.
That's right.
What is the percentage that I can raise?
But you've got 3 things going on here. 3.
Yeah.
So here's the 3. Number 1, you are one of those unusual people that are exempt from LA rent control based on the fact that you had a luxury exemption. Okay, that's 1. And you are under statewide rent control, but really you're not under statewide rent control because any property that is subject to Section 8 is not under statewide rent control. But when you're saying, how much can I raise it? The answer is you can't raise the rent because the only one who can raise the rent is Section 8. Section 8 can raise, you have to get permission from Section 8. If they give you permission, then you can raise rent anytime because you're not subject to any other rent control.
Well, I request it. You have to go through, the request process, and
they have to approve it.
Yeah. Well, the last year they rejected it for the first time because they said I wasn't under rent control. So Dan Yulkelson hooked me up with Anna Ortega, and she verified that I was under that I was exempt. So then they had to give me a retro back to January. They only give you 1 raise a year. So I'm ready to request my raise now. And I just wondered, I was going to go with whatever I just assumed, I was subject to statewide rent control. So I was just, well, how much should I raise the rent? What is okay, then just what is statewide rent control? What's the percentage?
It's whatever Section 8 says they'll give you. So you've got to get this approved, and whatever they say is what you're stuck with.
That's okay, but I want to know what to ask for.
Ask for market value. Let's go to rentometer.com, find out what your unit should go for and say, look, the market value for my unit, which is a 2-bedroom, is $2,700. So if you want me still to be part of this, okay, then I want $2,700. Now, what you can do, and this is a very clever thing, but we're working. Okay. If there's so much stuff going on in this board that I'm trying to control. This is kind of a technical argument, but I'm going to do it real quick, and then maybe you want to call me at the office.
Okay.
You can terminate a Section 8 tenant on the basis of economic reasons. That's one of the reasons to terminate a section. So you're going to go to your Section 8 advisor and you're going to say, I want, based on the comps, I want $2,700. They're going to say, yes, you're stuck. But if they say, no, we're only going to give you a pittance, not the full rent increase, then what we could do is we could serve on your tenant a 90-day notice that we're not terminating the tenant, that we're terminating Section 8, and we can raise that rent to a higher level to market value. And if the tenant wants to pay it, great. If the tenant wants to get a new voucher and move on, then that's great too. Okay, but that's a tricky thing that we're doing in one case. So if you want to talk to me about it, give me a call
I
at the office.
Yes.
All right, darling. Thank you
I'll
very much. I am going to move on now to,
Myself.
please mute yourself if you'd be so kind. Thank you. I'm going to move on to Virginia.
No.
I'm going to ask you to unmute yourself. Virginia, are you there? Got to unmute yourself, my love. God, I'm seeing you're muted. And if not, we're going to move on. Okay, we're going to move on. Sorry, Virginia. Try it again. Let's move on to Pete Figgle.
Hi, nice to
I'm
meet
going
you.
to ask you to unmute yourself.
I should be unmuted. Can you hear me?
Perfectly. You look great.
Okay, thank you so much. I'm looking to buy a property that has 2 units on it. And I'm trying to present like a pitch to the current owner that I'll kind of handle whatever needs to be handled with the current tenants. And I'm just curious, my rights as a new owner, what does it mean as far as kicking those people out? I know for a fact that one of these tenants has a special needs son, and that might add some additional variables.
Okay, well, first of all, as I always say, every time I get on the phone with a client, where is your property going to be?
In Los Angeles
Is this
County.
an apartment or a house?
It's a 10,000 square foot piece of land that has 2 separate houses on it.
And those houses obviously were built prior to 1979.
Yes.
So you were under LA rent control.
Okay.
So if you're under LA rent control, you can't ask tenants to move. You have
Even
to
if I'm a new owner?
even if you're being a new owner doesn't
okay.
change anything. All that means is you step into the shoes of the previous owner. So whatever he did or whatever he has, whatever rights he has is the exact same rights. People think, well, gee, I'm the new owner, I should be able to do anything. Well, if that was the case, look how easy it would be to get around rent control. I'd have the husband selling it to the wife and then the wife selling it to the husband. So that you're under the same auspices. You can't ask these people to move. If they have a handicapped person and they've been there longer than 10 years, you can't even put in a family member. Okay. You can't do a renovation eviction. The only thing you could do, which some people do, and I don't know if it makes sense for you, if you are a developer, we could demolish these houses and we could ask them to move based on something called the Ellis Act. So based on the Ellis Act, we would have the right to remove them from the premises. You're going to have to pay relocation, which is for at least the one with the handicapped person, at least $23,000. And I don't know how long the other person's been there or whether they're over 62 or have minor children. Then it would again be 23. Otherwise, it's about 12,000. But if you were planning on just bulldozing these houses and putting up some brand new,
That is exactly my plan. So I do have a right to do
oh,
that.
absolutely, yeah, because
Okay.
that's the only way you can do it. One of our attorneys at our office, Jennifer Hartman, she's a specialist at doing Ellis Act evictions. So buy the property with full confidence, we can get rid of these people. However, they do the notice after we get approval from the city, the tenant can ask for, you're supposed to serve a 120-day notice. And if in fact, the tenant is over 62 or there's handicapped people there, they can ask for 1 year's notice. So we can
really?
go through this and you might have to adjust your construction loans and your capitalization on this property to include 1 year where you're just going to be taking the rent that they owe.
For an owner occupation, how can you insure a vacant property for move-in? Does having 2 rentable units on the property change that?
Well, I mean, if once you become the owner, and this is whether it's a single family home or not, you have to go through an application process with the city. And once you go through an application process with the city, then you can serve on the tenant a 60-day notice and pay the relocation, but you're exempt. You can't be kicked out for an owner move-in if you've been there longer than 10 years, and you are over 62 or handicapped.
Okay.
But you're different. You're good because you're under the Ellis Act where, hey, I'm just permanently taking these units off of rental housing use. By doing that, we
Mhm.
have the right to get rid of these people. We got to pay the relocation, which if you're doing a project, the relocation money is nothing. It's 23,000. It's in the scope of things, it's nothing if you've got a plan to build those beautiful six-unit apartment house with the subterranean parking. All
No,
right, my friend,
wait, if
nice
you-
talking to you. Give us a call at the
quick
office.
question. If you take it off the rental market to build a single family home with an ADU, what are the limitations for use?
If you're just, well, you're not, if you're taking off those units to build an ADU, then you could be building anything, not just an ADU.
Okay,
Okay.
yeah.
All right, Pete, nice
you.
talking with you. Let's move on. Let's see, somebody new who I haven't picked on. You know what? I think it's time for Juan. Juan's iPhone, if you will please unmute yourself.
Am I unmuted?
You are. Look at you, guy.
Hi,
I know
I'm at
you're
work.
Juan because I can see your badge there. What do you do
Okay,
for a living,
thanks.
Juan?
I fix crash cars.
You fix what?
Crash cars, like a
Okay.
body shop.
Oh my God.
Yeah.
Oh, crash cars. I get it.
And on the side, I own some apartments. You are actually doing an eviction for me right now.
Well, that's great. I don't want to talk about specific cases, but if you want to talk about general information, I'm happy to do so.
Yes, I had a question. You know, with all this COVID stuff, some of my tenants have put a lot of outside storage in the property and extra cars and everything. I actually gave them a paper, like a 30-day notice to, you know, to take it off because even the housing department doesn't want outside storage on properties. But I downloaded all of your templates, and I'm wondering if I can give them one of those because they're not listening. And I want to actually get them
yeah,
ready
you-
for you to handle.
You certainly can. What city is this property?
It's in the LA Incorporated Torrance. A lot
Okay,
of
so
people
you're
think
in what
Torrance.
they say Torrance, but you're really in the city of Los Angeles.
Yes.
Okay,
Yes.
so it would be a notice to perform or quit. I really don't recommend you serving the notice yourself. We also have to, under the city rules, we have to prepare a copy for the city and fill out their form for the city as well. But I really need to take a look at the rental agreement. But you said you got a violation from the city. Is that correct?
Yeah, actually, a couple years ago, I got one from the fire department. And I asked them to clean, but no one listened. I took pictures, so I have pictures and I have the violation from the fire department.
Yeah, that would, if there's nothing in your rental agreement that tenants can't store property in the common areas, and there's two other ways we can go. One would either be the fact that you got this notice to comply from the city. That's a great one. Also, most people don't know that it is illegal by city rules to store inoperable cars on the property. And I bet you one of those cars are inoperable, and you'd be the best one to know since you're in that business.
Oh,
So
yeah,
you can
there's
also-
one or two.
What's that?
I'm sorry. Yeah, there is one or two of those also.
Right, so you're in violation of the city, so it's your patriotic duty to commence these evictions to get rid of these people with these inoperable cars. So you have some great cases here. I don't recommend you doing it yourself. When people do, it's so funny, they serve their own notices, they think they're right, then we start the case and we go, well, I'm gonna have to serve the notice again. So, but anyway, good luck to you, and thanks for joining us.
Thank you.
Take
Appreciate
care.
it.
Okay, so I am now going to move on to, let's get somebody here. Oh, here's a person. Let's do Roland. Mr. Roland, I'm going to ask you to unmute yourself. Are you there?
Yes, I'm here. Can you hear me?
I hear you fine. Thank you.
Hi. I'm going to be a first-time landlord here in Los Angeles, and
Why?
because I moved out of my one-bedroom apartment to move in with my fiance.
Mm-hmm.
We found a two-bedroom apartment for her, me, and her mom.
Okay.
So I'm currently preparing my one-bedroom condo in North Hollywood to rent. And quite frankly, all these questions are starting to worry me from other people. But I have a potential tenant. Someone in the building has friends who are interested in renting my unit, and we've been communicating back and forth. And I told this person that the rent will be $2,125. And earlier this week, they came back and told me that their friends are still interested, but it's a couple and a child. My first question is it okay to rent a one-bedroom condo apartment to 3 people residing in the home?
Well, the answer to that is that under rules dealing with fair housing, I like to call them unfair housing, but their rules are that it's 2 per bedroom plus 1. So for a 1-bedroom, that would be 3, and it would be considered discriminatory potentially if you didn't allow those people to move in. So I don't have a problem with that.
Okay, I don't have a problem with it either. But this person also told me that if they could have a cosigner, which I assume is someone who is not going to be living in the home. And someone from your office called me earlier today and answered my question about approaching that, and they told me to find a standard California guarantor agreement online that I could attach to your lease. I was planning on using the lease on your website, but I can't find a specific California guarantor agreement online. Can I just use any any guarantor agreement that I find online?
You can, but let me knock you off your wooden horse right here.
Okay.
There's a lot of ways to manage property and advice that can be given by different attorneys. If you think about it, there's this one court that I'm familiar with. It's called the United States Supreme Court. Have you ever heard of that court?
Oh, of course, yes.
Okay, well, every time there's a major decision, you got 4 judges going one way and 5 judges going another. So you'll see there's a lot of difference opinion. So my position is the person who is renting your unit does not have sufficient credit. That is something I would not rent to. So if you're looking for the guarantor because these people have poor credit, don't rent. Just forget it. Why do you want to chase after some guarantor, to help pay the rent? It makes no sense. The persons who are living in your unit must have sufficient credit. They will take care of your property better, and you won't be in a situation where you're having to call me to go forward with an eviction. So again, I don't believe in guarantors at all. And a guarantor that doesn't live, if you're going to take the guarantor, and I don't believe in it, make sure the guarantor is local. If you got this person with $5 billion in a bank account, but they live in Minnesota, it's worthless, that guarantor, to you. You want them close to where you are, number one. And if you're bound and determined to take a guarantor, you don't need a guarantor agreement. The best thing to do would just make him a third tenant. So whether he lives there or not, my daughter rented an apartment. And of course, my daughter, who's of such meager means, rented an apartment in Beverly Hills, of course, and I had to sign as a tenant on the lease. I never put a foot into that unit. Maybe once she invited me over, but that was it. So if you're bound and determined to have a guarantor, don't waste your time with the guarantor agreement. You want him as a tenant, because if you did start an eviction, you're going to name him the eviction case. You can't name a guarantor in an eviction case, because a guarantor is not unlawfully detaining the premises. Okay. So anyway, first thing, don't take it. Second thing, make them a tenant. You don't need to find that agreement. Okay.
So I could tell them, no, I don't want to take a guarantee. I don't want to
I
accept the
wouldn't
cosigner.
do that, my good friend. No.
Okay, there's nothing against the law for me telling them I won't take a cosigner.
No, I only want people whose credit is sufficient to be my tenant. If not, I'm not. You're just buying a problem. Do you really want to hire my firm? Is that really what you're looking for doing?
I hope I don't have to.
No, you don't. Nobody, listen, let me tell you something. Nobody wants to call a plumber, But if the drains are clogged, you gotta call that plumber, okay? And that's why I think people call me. I'm gonna move on, Roland, but
Thank you.
nice talking to you. Okay, let's move on to somebody new here. How's our time? No, 3:50. I do appreciate everybody showing up, and actually this was really nice that everybody put their cameras on so that we could see them, but based on that, I'm gonna still go to Jason Vadut. I think Jason might be a client of mine. If you would be so kind as to unmute yourself. Are you there, Jason?
Are you calling for Jason or Joseph?
Joseph, I'm sorry.
Oh, hey, how's it
Joseph,
going?
how are you?
Good, good. Thank you. How are you?
I'm good.
Okay. I have a question about doing negotiating relocations while you have an eviction pending.
Go ahead. What's your question?
Can you do that?
Of course. You can settle with anybody on any reason. You know, you could be in the middle of a big lawsuit with Google, who's suing Apple, and they're in the lawsuit. And then one says, hey, you want to settle the case? Sure. Okay. So there's nothing wrong with that. Walking over to the tenant and say, look, your credit's going to get muddied. Everybody's going to know you were evicted before. You might have a big judgment against you, or you might win the case. Who knows? Let's just settle it. I'm willing to, and then fill in the blanks.
Okay, so let me give a little bit more context. I was working on doing a relocation agreement with the tenants, and they kept dragging their feet, not signing it entirely, dragging their feet. So I finally started an eviction against them for non-payment of rent. And then later they're like, oh, we want to sign the relocation agreement. And they signed it, sent it to me. I haven't signed it. And I was just concerned that this somehow muddies my eviction. It doesn't?
I don't think it muddies your eviction unless you sign it, because until then, it's just an offer by them.
Okay, great.
I don't think that's an issue.
Okay. What's the deal with late fees? Like, can you give us a little bit of direction on whether we can have late fees, whether...
Most rental agreements have a provision for late fees that are not in accordance with the law. So if it's not in accordance with the law, then you can't ask for it. Most late fees that you'll see in rental agreements says, if you don't pay your rent by the 5th of the month, and there is a $35 charge, something, those are all illegal based on some case that came down about 10 years ago. If you want to see the proper language to see if your rental agreement has the proper language, go to my website, evict123.com, go to the free form section, scroll down to the lease, and then look at my paragraph dealing with late charges. You probably won't like it, but at least it's in accordance with the law. Okay, we're going to move on, but thank you very much, Joseph. And let's see, who do I got here? I think I'm going to take, let's take Victor. I don't think I asked you before. Victor, are you there? Mr. Victor.
Hey, this is Victor. Sorry for the background noise. I've got a toddler. My property is in Redondo Beach.
Is it a boy or a girl?
It's a boy.
Oh my God. And
a couple of boys. Property
oh my
in
God, I'm
Redondo
sorry for
Beach.
you.
I've got a couple of tenants that have been a little bit of a problem. The tenant replaced the filter on the fridge, on the ice maker. It caused about $30K worth of damage. I've since repaired everything, but they lived without a kitchen sink and, you know, half the kitchen for about 3 weeks. I don't want to evict them, but they have now had a lawyer contact me because they think that I owe them for inconvenience.
Can you believe that, ladies and gentlemen?
Isn't that crazy?
Did an illegal alteration by trying to run a water line sink to, correct me if I'm wrong, Victor, to the refrigerator so that he could have a built-in ice maker. Is that the story?
No. So we had an ice maker in the fridge, and all they did was change the water filter, but they did it incorrectly.
Okay.
It caused a leak that caused mold, and I had to rip out half the kitchen to fix it.
Quite frankly, what I'd be doing is I'd be filing, well, you probably used your insurance, but your insurance, if you didn't use your insurance, you should sue them for the damage they created. Okay, tell that attorney that it's laughable that their client is the one who created the problem, and it's going to be your pleasure to sue them unless you shut up. So how can they hold you responsible when it's their negligent act which created the issue? How is that
Okay.
possible?
I know.
So,
So
but
I
the
just
nerve
wanted
of
to,
these tenants are insane.
I just wanted to confirm that. I really appreciate you answering my question and confirming my beliefs. So I was just wondering, do I go back in guns blazing? And it sounds like I do.
Oh, definitely. Just go straight after them and really, but did you get insurance to take care of it?
Yeah, you know, I'm a first-time landlord, so I was like, I just want to get this done. And so I just had my insurance cover it, but they, you know, I told them about the whole thing. So they said they handle it in subrogation on the back end. So
Yeah, and they should go after them. By the way, we're all going to be calling Child Protective Services as soon as this is
So
over,
sorry.
just to let you know.
I apologize.
You know, it's okay. I find it very amusing. And,
Thank you so
and
much.
I love children, even though I'm sick of mine. All right. I will talk to you later. Okay, let's go to Allison. We got a few more minutes. Allison, if you could unmute yourself.
Hello, Dennis. I'm a client of yours. I have an eviction suit in progress. I'm sure you're aware.
This is my good friend Allison from
Pittsburgh, Pennsylvania.
There you go.
Yeah. So in the middle of everything that's gone on, and I don't think we've discussed.
Remember, we're not talking about your case, darling. We're only
Okay, so then
questions.
Okay,
Those are the rules.
more generally speaking, then, if some additional people simply show up in the unit, because you mentioned earlier about new people added to tenancy, is that new people added to a tenancy? How do you?
Well, if other people move into a unit, they're not authorized. So a landlord has choices. The choices are that you can either raise the rent based on the jurisdiction of where your property is, or you can make a demand for the strangers to move. And if they don't, then we have the right to evict everyone from the unit.
Does it affect the eviction case, or is it a
No, it wouldn't affect an eviction case.
Okay.
Everybody gets evicted.
Okay.
Okay, darling, we'll
good.
talk
Thank
later.
you.
I'm going to try to take a couple more here. Let's see if I go down the list here, if I see somebody else. Let's see here. I think we did Alejandra. Did we get Alejandra? I don't think so. Let's ask Alejandra. Are you there? Alejandra. Okay, gone. We're gonna do, I think we did Allison. Didn't we do Allison? No, I don't think we did. Oh, we did Allison. No, you're Allison. Okay, let's go to Janice.
Help.
Yes, there you are, Janice.
Hi, Dennis. I live in New York, but I have a rental property in Northern California. But my issue, I think, affects everybody in California. It's guns. I just found out after the fact that tenants who left had a large cache of unsecured guns. So I thought I'd call my insurance company and ask them, one of the big three in California, what the policy is. They said you will not be insured unless you raise their tenant insurance to $300,000 a year. All guns have to be secured and can have either 2 or 3 rounds of ammunition on the property per gun. My then property manager was pushing back on this. She said, look, that's really unworkable. But the insurance company made it quite clear that if anything happened that involved liability, that I would not be covered. So I'd like your input on what to do and what you think of this.
Oh, first of all, you said, did these tenants leave? They're gone now, or
yeah, I found this out after the fact from.
So they vacated.
They vacated. Yeah, I would
Okay.
also want to know, I forgot one thing. The insurance company also said if the tenant remains, has a year lease or whatever, a clause has to be added to the lease immediately, which I would assume would mean within a month or two, that outlines all of this, and the increased tenant's insurance needs to happen immediately.
Okay, well, first of all, under federal law, under California law, you're allowed to own guns. So that's number one.
Right.
And whatever an insurance company is telling you has nothing to do with what the law is. That's just their business model. Just like I could have a business model that I don't want to deal with people that wear glasses. That's my business model, but it doesn't mean that it has anything to do with the law. The tenant is allowed to possess guns, and the insurance company is allowed to make whatever rules they like. If you don't like the insurance company rules, then what you need to do is you need to get a different insurance policy. You can't force the tenant, once he's already in possession, to sign something new or maybe to pay a higher security deposit. If you want to continue on with their insurance, like any business relationship, then you merely have to comply with whatever they want. Otherwise, they have the right to say, hey, you know what? I don't want, Janice, I don't want to have you as my client. You're going to have to find a different insurance company. But
Well, I think my impression is that it's statewide, that all of them are asking this now because of.
right, and therefore maybe what you'd have to do, and it would be a reasonable decision, would be to put into your rental agreement the next time someone moves in saying, we do not allow weapons on the property. And even though the federal government and the state says you can, I don't want it because I might lose my insurance. So you're doing it for an economic reason. And you should have that clause if you're concerned, and I haven't heard this problem before, but if you are concerned, then I would certainly have that phrase in your rental agreement. And then if the tenant is found to have weapons, then you'd have the right to evict.
So I can, but I can add I could also add a clause, right, that just said you have to pay $300,000 in, you have to have $300,000 in tenants.
Yes, absolutely. You could add
Yeah.
that to the contract. Anyway,
Okay.
ladies and gentlemen, we made it past the hour. You guys are really good. I really appreciate this. We had one of the best sessions, and I'm going to be doing this every Saturday at 3 p.m. And I really enjoy you guys. Don't forget, if you need to call the office, it's 1-800-77-EVICT. Don't forget my website, evict123.com, where you can always learn how to get onto this. And once again, love you all. Have a great day.
Thanks.
Bye-bye, everybody.
Thank you, Dennis. Bye-bye.